Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
The law. What I don't want you to do is take notes. So if you have your notebooks up, put them down. Copies of the instructions are going to be made available to each and every one of you separately. Why am I not giving it to you now? Because I want you to listen to me with all intent. You'll get them later. During the instructions, we're going to take at least one, maybe more stretch breaks. We'll get through this. Ladies and gentlemen of the jury, you have heard all the evidence and the arguments of the attorneys, and now it is my duty to instruct you on the law that applies to this case. The law requires that I read the instructions to you. You will have these instructions in written form in the jury room to refer to during your deliberations. You must base your decision on the facts and the law. You have two duties to perform. First, you must determine what facts have been proved from the evidence received in this trial and not from any other source. A fact is something proved by the evidence or by stipulation. A stipulation is an agreement between the attorneys regarding the facts. Second, you must apply the law that I state to you to the facts as you determine them, and in this way arrive at your verdict and any finding that you're instructed to include in your verdict. You must accept and follow the law as I stated to you, regardless of whether you agree with it. If anything concerning the law said by the attorneys in their arguments or at any other time during the trial conflicts with my instructions, you must follow my instructions. You must not be influenced by pity for or prejudice against the defendant. You must not be biased against the defendant because she has been arrested for this offense, charged with a crime, or brought to trial. None of these circumstances is evidence of guilt, and you must not infer or assume from any or all of them that the defendant is more likely to be guilty than not guilty. You must not be influenced by sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the people and the defendant have a right to expect that you will conscientiously consider, weigh the evidence, apply the law, and reach a just verdict regardless of the consequences. If any rule, direction, or idea is repeated or stated in different ways in these instructions, no emphasis is intended and you must not draw any inference because of its repetition. Do not single out any particular sentence or any individual point or instruction and ignore the others. Consider the instructions as a whole and each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. Statements made by the attorneys during the trial are not evidence. However, if the attorneys have stipulated or agreed to a fact, you must regard that fact as proven. If an objection was sustained to a question, do not guess what the answer might have been. Do not speculate as to the reason for the objection. Do not assume to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it helps you to understand the answer. Do not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken by the court. Treat it as though you had never heard of it. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. When a witness has testified through a certified court interpreter, you must accept the English interpretation of that testimony even if you would have translated the foreign language differently. You must not independently investigate the facts or the law, or consider or discuss facts as to which there is no evidence. This means, for example, that you must not conduct experiments, visit or view the premises or place where the crimes charged were allegedly committed, or any other premises or place involved in this case. In addition, you must not conduct research or disseminate information on any subject. You must not discuss this case with any other person, including but not limited to spouses, spiritual leaders or advisors, or therapists, except a fellow juror during deliberations when all 12 of you are together in the jury room, and then only after the case is submitted to you for your decision, and only when all 12 jurors are present in the jury room. These prohibitions against conversation, research, and dissemination include, but are not limited to, all forms of electronic or wireless communication, such as radio, television, and the Internet. You've been given notebooks and pencils. You will be able to take them into the jury room when you deliberate. Notes are only an aid to memory and should not take precedence over recollection. A juror who did not take notes should rely upon his or her recollection of the evidence and not be influenced by the fact that other jurors did take notes. Notes are for the note-taker's own personal use in refreshing his or her recollection of the evidence. Finally, should any discrepancy exist between a juror's recollection of the evidence and a juror's notes, or between one juror's recollection and that of another, you may request that the reporter read back the relevant testimony which must prevail. Evidence consists of the testimony of witnesses, writings, material objects, or anything presented to the senses and offered to prove the existence or non-existence of a fact. Evidence is either direct or circumstantial. Direct evidence is evidence that directly proves a fact. It is evidence which, by itself, if found to be true, establishes that fact. Circumstantial evidence is evidence that, if found to be true, proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. It is not necessary that facts be proved by direct evidence. They also may be proved by circumstantial evidence or by a combination of direct and circumstantial evidence. Both direct and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only 1, consistent with the theory that the defendant is guilty of the crime, but 2, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance on which the inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count permits 2 reasonable interpretations, one of which points to the defendant's guilt and the other to her innocence, you must adopt that interpretation that points to the defendant's innocence and reject that interpretation that points to her guilt. If, on the other hand, one interpretation of this evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. If you find that the defendant attempted to suppress evidence against herself in any manner, such as by an offer to compensate a witness, by destroying, such as by destroying evidence or by concealing evidence, this attempt may be considered by you as a circumstance tending to show a consciousness of guilt. However, this conduct is not sufficient by itself to prove guilt, and its weight and significance, if any, are for you to decide. Neither side is required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence or who may appear to have some knowledge of these events. Neither side is required to produce all objects or documents mentioned or suggested by the evidence. There has been evidence in this case indicating that a person other than the defendant, Robert Baker, or Christopher Austin was or may have been involved in the crime for which the defendant is on trial. There may be many reasons why that person is not here on trial. Therefore, do not speculate or guess as to why the other person is not being prosecuted in this trial, or whether he has been or will be prosecuted. Your sole duty is to decide whether the people have proved the guilt of the defendant on trial. Evidence that at some other time a witness made statements that are inconsistent or consistent with his or her testimony in this trial may be considered by you not only for the purpose of testing the credibility of the witness, but also as evidence of the truth of the facts as stated by the witness on that former occasion. If you disbelieve a witness's testimony that he or she no longer remembers a certain event, that testimony is inconsistent with a prior statement or statements by him or her describing that event. Every person who testifies under oath is a witness. You are the sole judges of the believability of a witness and the weight to be given the testimony of each witness. In determining the believability of a witness, you may consider anything that has a tendency reasonably to prove or disprove the truthfulness of the testimony of the witness, including but not limited to any of the following: the extent of the opportunity or ability of the witness to see or hear or otherwise become aware of any matter about which the witness testifies, the ability of the witness to remember or to communicate any matter about which the witness has testified, the character and quality of that testimony, the demeanor and manner of the witness while testifying, the existence or non-existence of a bias, interest, or other motive, the existence or non-existence of any fact testified to by the witness, the attitude of the witness toward this action or toward the giving of testimony, a statement previously made by the witness that is consistent or inconsistent with his or her testimony, an admission by the witness of untruthfulness, the witness's prior conviction of a felony, and whether the witness is testifying under a grant of immunity or leniency. Discrepancies in a witness's testimony, or between a witness's testimony and that of other witnesses, if there were any, do not necessarily mean that any witness should be discredited. Failure of recollection is common. Innocent misrecollection is not uncommon. Two persons witnessing an incident or a transaction often will see or hear it differently. You should consider whether a discrepancy relates to an important matter or only to something trivial. A witness who is willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point, unless from all the evidence you believe the probability of truth favors his or her testimony in other particulars. You are not required to decide any issue of fact in accordance with the testimony of a number of witnesses which does not convince you, as against the testimony of a lesser number or other evidence which you find more convincing. You may not disregard the testimony of the greater number of witnesses merely from caprice, whim, or prejudice, or from a desire to favor one side against the other. You must not decide an issue by the simple process of counting the number of witnesses who have testified on the opposing sides. The final test is not in the relative number of witnesses, but in the convincing force of the evidence. The fact that a witness has been convicted of a felony, if this is a fact, may be considered by you only for the purpose of determining the believability of that witness. The fact of a conviction does not necessarily destroy or impair a witness's believability. It is one of the circumstances that you may consider in weighing the testimony of that witness. You should give the testimony of a single witness whatever weight you think it deserves. Testimony concerning any fact by one witness which you believe, whose testimony about that fact does not require corroboration, is sufficient for the proof of that fact. You should carefully review all the evidence upon which the proof of that fact depends. The mere fact that a witness is in custody or is in physical restraint must not prejudice you for or against any party. That a witness is in custody or subject to physical restraint is not by itself evidence that a witness is or is not believable. Motive is not an element of the crime charged and need not be shown. However, you may consider motive or lack of motive as a circumstance in this case. Presence of motive may tend to establish the defendant is guilty. Absence of motive may tend to show the defendant is not guilty. A defendant in a criminal trial has a constitutional right not to be compelled to testify. You must not draw any inference from the fact that a defendant does not testify. Further, you must neither discuss this matter nor permit it to enter into your deliberations in any way. In deciding whether or not to testify, the defendant may choose to rely on the state of the evidence and upon the failure, if any, of the people to prove beyond a reasonable doubt every essential element of the charge against her. No lack of testimony on the defendant's part will make up for a failure of proof by the people, so as to support a finding against her on any essential element. A confession is a statement made by a defendant on which she has acknowledged her guilt of the crimes for which she is on trial. In order to constitute a confession, the statement must acknowledge participation in the crimes as well as the required criminal intent or state of mind. An admission is a statement made by the defendant which does not by itself acknowledge her guilt of the crimes for which the defendant is on trial, but which statement tends to prove her guilt when considered with the rest of the evidence. You are the exclusive judges as to whether the defendant made a confession or an admission, and if so, whether that statement is true in whole or in part. Evidence of an oral confession or an oral admission of the defendant, not contained in an audio or video recording, and not made in court, should be viewed with caution. If you should find from the evidence that there was an occasion when the defendant, 1, under conditions which reasonably afforded her an opportunity to reply, 2, failed to make a denial or made false, evasive, or contradictory statements in the absence of an accusation expressed directly to her or in her presence, charging her with the crime for which this defendant now is on trial, or tending to connect her with its commission, and 3, that she heard the accusation and understood its nature, then the circumstance of her silence and conduct on that occasion may be considered against her as indicating an admission that the accusation was true. Evidence of an accusatory statement is not received for the purpose of proving its truth, but only as it supplies meaning to the silence and conduct of the accused in the face of it. Unless you find that the defendant's silence and conduct at the time indicated an admission that the accusatory statement was true, you must entirely disregard the statement. No person may be convicted of a criminal offense unless there is some proof of each element of the crime independent of any confession or admission made by her outside of this trial. The identity of the person who is alleged to have committed a crime is not an element of the crime, nor is the degree of the crime. The identity or degree of the crime may be established by confession or admission. Witnesses who have special knowledge, skill, experience, training, or education in a particular subject have testified to certain opinions. This type of witness is referred to as an expert witness. In determining what weight to give to any opinion expressed by an expert witness, you should consider the qualifications and the believability of the witness, the facts or materials upon which each opinion is based, and the reasons for each opinion. The opinion is only as good as the facts and reasons on which it is based. If you find that any fact has not been proved or has been disproved, you must consider that in determining the value of the opinion. Likewise, you must consider the strengths and weaknesses of the reasons on which it is based. You are not bound by an opinion. Give each opinion the weight you find it deserves. You may disregard any opinion if you find it to be unreasonable. In examining an expert witness, counsel may ask a hypothetical question. This is a question in which the witness is asked to assume the truth of the set of facts and to give an opinion based on that assumption. In permitting this type of question, the court does not rule and does not necessarily find that all of the assumed facts have been proved. It only determines that those assumed facts are within the possible range of the evidence. It is for you to decide from all of the evidence whether or not the facts assumed in a hypothetical question have been proved. If you should decide that any assumption in the question has not been proved, you already determined the effect of that failure of the proof on the value and weight of the expert opinion based on the assumed facts. In resolving any conflict that may exist in the testimony of expert witnesses, you should weigh the opinion of one expert against that of another. In doing this, you should consider the qualifications and the believability of each witness, the reasons for each opinion, and the matter upon which it is based. Persons who are involved in committing a crime are referred to as principals in that crime. Except as to the crime of murder, each principal, regardless of the extent or manner of participation, is equally guilty. Principals include 1, those who directly and actively commit the act constituting the crime, or 2, those who aid and abet the commission of the crime. When the crime charged is murder, the aider and abettor's guilt is determined by the combined acts of all the participants as well as that person's own mental state. If the aider and abettor's mental state is more culpable than that of the actual perpetrator, that person's guilt may be greater than that of the actual perpetrator. Similarly, The aider and abettor's guilt may be less than that of the perpetrators if the aider and abettor has a less culpable mental state. A person aids and abets the commission of a crime when he or she, 1, with knowledge of the unlawful purpose of the perpetrator, and 2, with the intent or purpose of committing or encouraging or facilitating the commission of the act or crime, and 3, by act or advice, aids, promotes, encourages, or instigates the commission of the act or crime. A person who aids and abets the commission of a crime need not be present at the scene of the crime. Mere presence at the scene of a crime, which does not itself assist the commission of the crime, does not amount to aiding and abetting. To be guilty as an aider or abettor, the defendant's intent or purpose of committing or encouraging or facilitating the commission of the act or crime by the perpetrator must be formed before or during the commission of the act or crime. Mere knowledge that a crime is being committed and the failure to prevent it does not amount to aiding and abetting. An accomplice is a person who was subject to prosecution for the identical offense charged against the defendant on trial by reason of aiding and abetting or being a member of a criminal conspiracy. You cannot find the defendant guilty based upon the testimony of an accomplice unless that testimony is corroborated by other evidence which tends to connect the defendant with the commission of the offense. Testimony of an accomplice includes any out-of-court statement purportedly made by an accomplice, received for the purpose of proving that what the accomplice stated out of court was true. To corroborate the testimony of an accomplice, there must be evidence of some act or fact related to the crime which, if believed, by itself and without any aid, interpretation, or direction from the testimony of the accomplice, tends to connect the defendant with the commission of the crime charged. However, it is not necessary that the evidence of corroboration be sufficient in itself to establish every element of the crime charged, or that it corroborate every fact to which the accomplice testifies. In determining whether an accomplice has been corroborated, you must first assume the testimony of the accomplice has been removed from the case. You must then determine whether there is any remaining evidence which tends to connect the defendant with the commission of the crime. If there is no independent evidence which tends to connect the defendant with the commission of the crime, the testimony of the accomplice is not corroborated. If there is independent evidence which you believe, then the testimony of the accomplice is corroborated. Required corroboration of the testimony of an accomplice may not be supplied by the testimony of any or all of his accomplices, but must come from other evidence. If the crime of murder or conspiracy to commit murder was committed by anyone, the witnesses Robert Baker and Christopher Austin were accomplices as a matter of law, and their testimony is subject to the rule requiring corroboration. To the extent that an accomplice gives testimony that tends to incriminate the defendant, it should be viewed with caution. This does not mean, however, that you may arbitrarily disregard that testimony. You should give that testimony the weight you think it deserves after examining it with care and caution and in light of all the evidence in this case. In the crimes and allegations charged, there must exist a union or joint operation of act or conduct and a certain specific intent or mental state in the mind of the perpetrator. Unless this specific intent or mental state exists, the crime or allegation to which it relates is not committed or is not true. The specific intent or mental state required is included in the definitions of the crimes or allegations set forth elsewhere in these instructions. A defendant in a criminal action is presumed to be innocent until the contrary is proved. In the case of a reasonable doubt whether her guilt is satisfactorily shown, she is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving her guilty beyond a reasonable doubt. Reasonable doubt is defined as follows. It is not a mere possible doubt because everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction of the truth of the charge. Let's stretch. Defendant is accused of count 1 of having committed the crime of murder, a violation of Section 187 of the Penal Code. Every person who unlawfully kills a human being with malice aforethought is guilty of the crime of murder in violation of Penal Code Section 187. A killing is unlawful if it was neither justifiable nor excusable. In order to prove this crime, each of the following elements must be proved. 1. A human being was killed. 2. The killing was unlawful. And 3. The killing was done with malice aforethought. Malice may be either express or implied. Malice is expressed when there is manifested an intention unlawfully to kill a human being. Malice is implied when 1. The killing resulted from an intentional act. 2. The natural consequences of the act are dangerous to human life. And 3. The act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When it is shown that a killing resulted from the intentional doing of an act with express or implied malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or the lapse of a considerable time. It only means that the required mental state must precede rather than follow the act. Murder is classified into 2 degrees. If you should find the defendant guilty of murder, you must determine and state in your verdict whether you find the murder to be of the 1st or 2nd degree. All murder which is perpetrated by any kind of willful, deliberate, and premeditated killing with express malice aforethought is murder of the 1st degree. The word willful, as used in this instruction, means intentional. The word deliberate, which relates to how a person thinks, means formed or arrived at or determined upon as a result of careful thought and weighing of consideration for and against the proposed course of action. The word premeditated relates to when a person thinks and means considered beforehand. One premeditates by deliberating before taking action. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was a result of deliberation and premeditation, so it must have been formed upon pre-existing reflection and not under a sudden heat of passion or the condition precluding the idea of deliberation, it is murder of the 1st degree. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the 1st degree. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such a choice, and having in mind the consequences, he or she decides to and does kill. Murder which is immediately preceded by lying in wait is also murder of the 1st degree. The term lying in wait is defined as a waiting and watching for an opportune time to act, together with a concealment by ambush or by some other secret design to take the other person by surprise, even though the victim is aware of the murderer's presence. The lying in wait need not continue for any particular period of time, provided that its duration be substantial. That is, an amount of time that shows the killer had a state of mind equivalent to premeditation or deliberation. The word deliberation relates to how a person thinks. It means formed or arrived at or determined upon as a result of careful thought and weighing of consideration for and against the proposed course of action. The word premeditation, which relates to when a person thinks, means considered beforehand. One premeditates by deliberating before taking action. Murder of the 2nd degree is the unlawful killing of a human being with malice aforethought, when the perpetrator intended unlawfully to kill a human being, but the evidence is insufficient to prove deliberation and premeditation or lying in wait. Murder of the 2nd degree is also the unlawful killing of a human being when 1. The killing resulted from an intentional act, 2. The natural consequences of the act are dangerous to human life, And 3, the act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When the killing is the direct result of such an intentional act, it is not necessary to prove that the defendant intended that the act would result in the death of a human being. If any juror is convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but has a reasonable doubt whether the murder was of the first or the second degree, that juror must give the benefit of that doubt, must give the defendant the benefit of that doubt and find the murder to be of the second degree. If you find the defendant in this case guilty of murder of the first degree, you must then determine if one or more of the following special circumstances are true or not true: murder for financial gain and murder by means of lying in wait. The people have the burden of proving the truth of a special circumstance. If you have a reasonable doubt as to whether a special circumstance is true, you must find it to be not true. You cannot find a special circumstance to be true unless you are satisfied beyond a reasonable doubt that such defendant with the intent to kill aided, abetted, counseled, commanded, induced, solicited, requested, or assisted any actor in the commission of the murder in the first degree. You must decide separately each special circumstance alleged in this case. If you cannot agree as to all of the special circumstances but can agree as to one, you must make your finding as to the one upon which you agree. In order to find a special circumstance alleged in this case to be true or untrue, you must agree unanimously. You will state your special finding as to whether the special circumstance is or is not true on a form that will be provided. To find that the special circumstance referred to in these instructions as murder for financial gain is true, each of the following facts must be proved. 1. The murder was intentional. 2. It was carried out for financial gain. And 3. The defendant believed the death of the victim would result in the desired financial gain. To find that the special circumstance referred to in these instructions as murder by means of lying in wait is true, each of the following facts must be proved. 1. The defendant intentionally killed the victim. And 2. The murder was committed by means of lying in wait. Murder which is immediately preceded by lying in wait is a murder committed by means of lying in wait. The term lying in wait is defined as a waiting and watching for an opportune time to act, together with concealment by ambush or some other secret design to take the other person by surprise, even though the victim is aware of the murderer's presence. The lying in wait need not continue for any particular period of time, provided that its duration be substantial and that an amount of time that shows the killer had a state of mind equivalent to premeditation or deliberation. The word premeditation relates to when a person thinks and means considered beforehand. The word deliberation, which relates to how a person thinks, means formed or arrived at or determined upon as a result of careful thought and weighing of considerations for and against the proposed course of action. A person premeditates by deliberating before taking action. You are not permitted to find a special circumstance alleged in this case to be true based on circumstantial evidence unless the proved circumstance is not only 1, consistent with the theory that a special circumstance is true, but 2, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the truth of a special circumstance must be proved beyond a reasonable doubt. In other words, before an inference essential to establish a special circumstance may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which that inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence is susceptible of 2 reasonable interpretations, one of which points to the truth of a special circumstance and the other to its untruth, you must adopt the interpretation which points to its untruth and reject the interpretation which points to its truth. If, on the other hand, one interpretation of that evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. In your deliberations, the subject of penalty or punishment is not to be discussed or considered by you. That it is a matter which must not in any way affect your verdict or affect your finding as to the special circumstances alleged in this case. The defendant is accused in count 2 of having committed the crime of a conspiracy to commit murder in violation of section 182, subdivision A, subdivision 1 of the Penal Code. Every person who conspires with any other person or persons to commit the crime of murder is guilty of a violation of Penal Section 182, Subsection A, Subsection 1, a crime. Murder is the unlawful killing of a human being with malice aforethought. A conspiracy to commit murder is an agreement entered into between two or more persons with the specific intent to agree to commit the crime of murder and with the further specific intent to commit that murder, followed by an overt act committed in this state by one or more of the parties for the purpose of accomplishing the object of the conspiracy. Conspiracy is a crime. The crime of conspiracy to commit murder requires proof that the conspirators harbored express malice aforethought, namely the specific intent to kill unlawfully another human being. In order to find a defendant guilty of conspiracy, in addition to proof of the unlawful agreement and specific intent, there must be proof of the commission of at least one of the acts alleged in the information, strike that, in the indictment, to be an overt act, and that the act found to have been committed was an overt act. It is not necessary to the guilt of any particular defendant that the defendant personally committed an overt act if she was one of the conspirators when the overt act was committed. The term overt act means any step taken or act committed by one or more of the conspirators which goes beyond mere planning or agreement to commit a crime, and which step or act is done in furtherance of the accomplishment of the object of the conspiracy. To be an overt act, the step taken or act committed need not in and of itself constitute the crime or even an attempt to commit the crime which is the ultimate object of the conspiracy. Nor is it required that the step or act in and of itself be criminal or an unlawful act. The jury need not be unanimous as to which particular overt act was proved, as long as the jury is unanimous that at least one overt act was proved. In order to prove this crime, each of the following elements must be proved. 1. Each of the persons entered into an agreement to kill unlawfully another human being. 2. Each of the persons specifically intended to enter into an agreement with one or more other persons for that purpose. 3. Each of the persons to the agreement harbored express malice aforethought, namely a specific intent to kill unlawfully another human being. And 4. An overt act was committed in the state by one or more of the persons who agreed and intended to commit murder. Each member of a criminal conspiracy is liable for each act and bound by each declaration of every other member of the conspiracy if that act or declaration is in furtherance of the object of the conspiracy. The act of one conspirator pursuant to or in furtherance of the common design of the conspiracy is the act of all conspirators. The formation and existence of a conspiracy may be inferred from all of the circumstances tending to show the common intent and may be proved in the same way as any other fact may be proved, either by direct testimony of the fact or by circumstantial evidence, or by both direct and circumstantial evidence. It is not necessary to show a meeting of the alleged conspirators or the making of an express or formal agreement. Evidence that a person was in the company of or associated with one or more other persons alleged or proved to have been members of a conspiracy is not in itself sufficient to prove that person was a member of the alleged conspiracy. It is not a defense to the crime of conspiracy that an alleged conspirator did not know all the other conspirators. The member of a conspiracy may be widely separated, or the members of a conspiracy may be widely separated geographically, and yet may be in agreement on a criminal design and may act in concert in pursuit of that design. The adoption by a person of the criminal design and criminal intent entertained in common by others and of its object and purposes is all that is necessary to make that person a co-conspirator with the required elements of a conspiracy are present, when the required elements of a conspiracy are present. Where a conspirator commits an act or makes a declaration which is neither in furtherance of the object of the conspiracy, nor the natural and probable consequence of an attempt to attain that object, he or she alone is responsible for and is bound by that act or declaration, and no criminal responsibility therefore attaches to any of his or her confederates. The act or declaration of a person who is not a member of a conspiracy is not binding upon the members of the conspiracy, even if the act or declaration tended to promote the object of the conspiracy. Evidence of the commission of an act which furthered the purposes of an alleged conspiracy is not in itself sufficient to prove that the person committing the act was a member of the alleged conspiracy. No act or declaration of a conspirator committed or made after the conspiracy has been terminated is binding upon co-conspirators, and they are not criminally liable for that act. In this case, the defendant is charged with conspiracy to commit the crime or the following public crime: murder. It is alleged that the following overt acts were committed in the state by one or more of the defendants and were overt acts and committed for the purpose of furthering the object of the conspiracy. 1. Defendant Monica Sementilli and her lover, Robert Louis Baker, agreed to kill defendant Monica Sementilli's husband, Fabio Sementilli. 2. Defendant Monica Sementilli and Robert Louis Baker planned to obtain victim Fabio Sementilli's life insurance proceeds after he was murdered. 3. Defendant Monica Sementilli and Robert Louis Baker planned to live together once victim Fabio Sementilli was dead. 4. Defendant Monica Sementilli and Robert Louis Baker communicated via cell phones and encrypted communication applications regarding their plan to kill victim Fabio Sementilli. 5. Defendant Monica Sementilli called Robert Louis Baker over 9,000 times over the course of the year preceding the murder of her husband, Fabio Sementilli. 6. Robert Louis Baker called defendant Monica Sementilli over 17,000 times over the course of the year preceding the murder of victim Fabio Sementilli. 7. Robert Louis Baker solicited an unknown co-conspirator to assist him in killing victim Fabio Sementilli. 8. Defendant Monica Sementilli met with representatives from First Digital Surveillance to upgrade and install remote access to a residential video surveillance system on June 28, 2016. 9. Subsequently, on June 28, 2016, defendant Monica Sementilli requested assistance from First Digital Surveillance via text message to set up remote access to her residential video surveillance system via her cell phone. 10. Monica Sementilli received a digital DVR instruction manual from First Digital Surveillance to enable her to remotely view her residential video surveillance security cameras live via her cell phone. 11. Defendant Monica Sementilli sent a text message on June 28, 2016 to the owner of First Digital indicating she was able to connect her cell phone to her home surveillance system for remote access. 12. Defendant Monica Sementilli forwarded an email containing her security password, IP address, username, and instruction manual on how to access her home video surveillance system to her lover, Robert Louis Baker, on June 28, 2016. 13. Both defendant Monica Sementilli and Robert Louis Baker downloaded the computer application, allowing them to live stream the Sementilli home surveillance security cameras from their cell phones while simultaneously having a FaceTime communication. 14. Defendant Monica Sementilli described and or showed the location of the DVR in her garage to Robert Louis Baker. 15. Defendant Monica Sementilli notified Robert Louis Baker that victim Fabio Sementilli would be alone at home during the afternoon on January 23, 2017. 16. Defendant Monica Sementilli and Robert Louis Baker communicated via cell phone 23 times between January 18, 2017 and January 25, 2017. 17. On January 23, 2017, defendant Monica Sementilli went to the Woodland Hills LA Fitness Gym in order to make contact with Robert Louis Baker. 18. On January 23, 2017, defendant Monica Sementilli confirmed that her housekeeper would be finished cleaning and leave the Sementilli residence by 2:30 p.m. so that there would be no witnesses present for the murder of her husband, victim Fabio Sementilli, by Robert Louis Baker. 19. On January 23, 2017, ensured that her oldest daughter, Jessica Sementilli, would be out of the home at a babysitting job in the afternoon so as to leave victim Fabio Sementilli alone without any witnesses present so he could be murdered by Robert Louis Baker. 20. Defendant Monica Sementilli drove to Target in Woodland Hills in order to meet with Robert Louis Baker and establish her alibi. 21. Defendant Monica Sementilli entered the Target parking lot at approximately 3:30 p.m. and picked up Robert Louis Baker and parked her car in a remote area of the lot. 22. After Robert Louis Baker got out of Defendant Monica Sementilli's vehicle, Defendant Monica Sementilli reparked in the Target parking lot near the store. 23. While in the Target parking lot, Defendant Monica Sementilli sat in her car and called her daughter, Jessica, to coordinate the available murder timeline with Robert Louis Baker. 24. Defendant Monica Sementilli entered Target at 3:38 p.m. and remained inside for approximately 1 hour to establish her alibi. 25. While at Target at approximately 4 o'clock p.m., Defendant Monica Sementilli used her cell phone to connect to her home IP address and monitor her home surveillance cameras utilizing significant amounts of data. 26. At approximately 4:18 p.m., Robert Louis Baker and an unknown co-conspirator jogged up to victim Fabio Sementilli's home from Oakdale Avenue to Queen Victoria Road while armed with a knife. 27. Upon arriving at the Sementilli home, Robert Louis Baker checked the surveillance security cameras via his cell phone to attempt to determine victim Fabio Sementilli's location at the residence. 28. Robert Louis Baker and an unknown co-conspirator entered the residence. 29. After leaving Target at approximately 4:36 p.m., Defendant Monica Sementilli went to the Ralph's Market in Woodland Hills in order to establish another alibi. 30. Upon entering the Sementilli residence, Robert Louis Baker and an unknown co-conspirator walked into the living room, dining room, and/or kitchen and observed victim Fabio Sementilli sitting on the back patio through the windows. 31. Robert Louis Baker and an unknown co-conspirator attacked victim Fabio Sementilli from behind as he sat with his back to the kitchen door. 32. While stabbing victim Fabio Sementilli to death, Robert Louis Baker cut his left index finger. 33. Robert Louis Baker and an unknown co-conspirator murdered victim Fabio Sementilli in furtherance of the conspiracy with defendant Monica Sementilli to collect the victim's life insurance proceeds. 34. Robert Louis Baker went into the kitchen to wash off the victim's blood and destroy evidence, leaving his own blood behind. 35. Robert Louis Baker and an unknown co-conspirator attempted to clean the crime scene and destroy evidence. 36. Robert Louis Baker and an unknown co-conspirator attempted to stage a robbery and/or burglary in the master bedroom. 37. Robert Louis Baker and an unknown co-conspirator went into the garage and removed the DVR for the home surveillance security system from the top of cabinet as previously described and pointed out by defendant Monica Sementilli. 38. Robert Louis Baker and an unknown co-conspirator turned off the circuit breakers in the garage, cutting off power to the home. 39. At approximately 4:53 p.m., Robert Louis Baker and an unknown co-conspirator took and drove away victim Fabio Sementilli's Porsche 911 from the residence to stage the crime scene as a robbery and/or burglary. 40. 4 hours later, Robert Louis Baker parked victim Fabio Sementilli's Porsche on Khalifa Street in Woodland Hills in order to stage the crime as a robbery and/or burglary and fled the scene. 41. Defendant Monica Sementilli left the Ralph's Market at approximately 4:52 p.m. 42. Defendant Monica Sementilli waited for her younger daughter, Isabella, to arrive home first and find her father's body at approximately 4:55 p.m. 43. Defendant Monica Sementilli coordinated the time with Robert Louis Baker so she would arrive home immediately after her daughter at approximately 5:03 p.m. 44. On January 23, 2017, defendant Monica Sementilli lied to LAPD detective Parshall that she was unaware that she had killed her husband. 45. After the murder on January 23, 2017, defendant Monica Sementilli contacted victim Fabio Sementilli's company, Wella Professionals / Cody, through a friend to make a claim for his life insurance policy proceeds. 46. Subsequently, defendant Monica Sementilli contacted MetLife Insurance and Wella Professional / Cody to make claims for her husband's life insurance policy proceeds. 47. After the murder, defendant Monica Sementilli called LAPD detectives several times inquiring why her husband's life insurance policy proceeds were being withheld. 48. On January 29, 2017, at a gathering at her home, after the funeral, defendant Monica Sementilli and Robert Louis Baker went into the master bedroom to discuss and arrange their continuing fabricated stories to law enforcement, friends, and family. 49. On May 18, 2017, defendant Monica Sementilli told LAPD Detective Parshall, Tellis, and Gable that she desperately needed her husband's life insurance policy money in order to continue to run her household, despite secretly spending money on travels with Robert Louis Baker. 50. On May 18, 2017, defendant Monica Sementilli lied to LAPD RHD detectives Tellis and Gable, pretending that she was uncertain of the last name of her lover and co-conspirator, Robert Louis Baker. 51. On May 18, 2017, defendant Monica Sementilli lied to LAPD RHD detectives that she did not know how to access her home surveillance system remotely via her cell phone. 52. Between March 26 and March 28, 2017, defendant Monica Sementilli posted photographs and statements indicating her alleged sadness over the death of her husband in order to provide a cover for her participation in the murder while having sexual relations with Robert Louis Baker in a Las Vegas hotel room. 53. Defendant Monica Sementilli called her husband's older son, Luigi Sementilli, and requested $30,000 from one of the victim Fabio Sementilli's life insurance policies. 54. Defendant Monica Sementilli contacted her husband's family and requested their assistance in obtaining money from her husband's life insurance policies and asked them to draft a letter to MetLife Insurance Company and Wella Professionals / Cody via Detective Parshall on her behalf. 55. Defendant Monica Sementilli and Robert Louis Baker manufactured a false story to explain away the DNA evidence recovered at the crime scene belonging to defendant Robert Louis Baker. 56. Defendant Monica Sementilli and Robert Louis Baker lied to law enforcement and pretended they were uninvolved in the murder of victim Fabio Sementilli so they could avoid arrest and prosecution and collect his life insurance proceeds. Evidence of a statement made by one alleged conspirator other than at this trial shall not be considered by you against another alleged conspirator unless you determine by preponderance of the evidence that 1. That from the other independent evidence that at the time the statement was made, a conspiracy to commit a crime existed. 2. That the statement was made while the person making the statement was participating in the conspiracy. 3. That the statement was made in furtherance of the objective of the conspiracy and was made before or during the time when the party against whom it was offered was participating in the conspiracy. And the word statement as used in this instruction includes any oral or written verbal expression or the nonverbal conduct of a person intended by that person as a substitute for oral or written verbal expression. Let's stretch again. Each count charges a distinct crime. You must decide each count separately. The defendant may be found guilty or not guilty of either or both of the crimes charged. Your finding as to each count must be stated in a separate verdict. I have not intended by anything I have said or done, or by any questions that I may have asked, or by any ruling I may have made to intimate or suggest what you should find to be the facts, or that I believe or disbelieve any witness. If anything I have done or said that seems to indicate, you will disregard it and form your own conclusion. The purpose of the court's instructions is to provide you with the applicable law so that you may arrive at a just and lawful verdict. Whether some instructions apply will depend upon what you find to be the facts. Disregard any instruction which applies to facts determined by you not to exist. Do not conclude that because an instruction has been given that I am expressing an opinion as to the facts. The people and the defendant are entitled to the individual opinion of each juror. Each of you must consider the evidence for the purpose of reaching a verdict if you can do so. Each of you must decide the case for yourself, but should do so only after discussing the evidence and the instructions with the other jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, do not decide any question in a particular way because a majority of the jurors, or any of them, favor that decision. Do not decide any issue in this case by the flip of a coin or by any other chance determination. The attitude and conduct of jurors at all times are very important. It is rarely helpful for a juror at the beginning of deliberations to express an emphatic opinion on the case or to announce a determination to stand for a certain verdict. When one does that at the outset, a sense of pride may be aroused, and one may hesitate to change a position even if shown that it is wrong. Remember that you are not partisans or advocates in this matter. You are the impartial judges of the facts. In your deliberations, do not discuss or consider the subject of penalty or punishment. That subject must not in any way affect your verdict. During deliberations, any question or request you may have should be addressed to the court on a form that will be provided. If there is any disagreement as to the actual testimony, you have the right, if you choose, to request a readback by the reporter. You may request a partial or a total readback, but any readback should be a fair presentation of that evidence, and if a readback of testimony is requested, the reporter will delete objections, rulings, and sidebar conferences so that you will hear only the evidence that was actually presented. Please understand that counsel must first be contacted, and it may take time to provide a response or a readback. Continue deliberating until you are called back into the courtroom. The instructions which I am now giving to you will be made available in written form for your deliberations. They must not be defaced in any way. You will find that the instructions may be typed, printed, or handwritten. Portions may have been added or deleted. You must disregard any deleted part of an instruction and not speculate as to what it was or as to the reason for its deletion. You are not to be concerned with the reasons for any modification. Every part of the text of an instruction, whether typed, printed, or handwritten, is of equal importance. You are to be governed only by the instruction in its final wording. Do not disclose to anyone outside the jury, not even to me or any member of my staff, how, either orally or in writing, how you may be divided numerically in your balloting as to any issue unless I specifically direct otherwise. You will be permitted to separate at the noon and evening recesses. During your absence, the courtroom will be locked. You are to return following the recess at 1:30 p.m. and at 9:00 a.m. on the next succeeding court date. During periods of recess, it is your duty not to conduct research, disseminate information, or converse among yourselves or with anyone else on any subject connected with this trial, or to form or express an opinion about the case until the cause is finally submitted to you. This prohibition on research, dissemination of information, and conversation includes, but is not limited to, any form of electronic or wireless communication, such as radio, television, and the Internet. You must not deliberate further upon the case until all 12 of you are together and reassembled in the jury room. At that time, you shall notify the clerk or the bailiff that the jury is reassembled, and then continue your deliberations. During deliberations, the bailiff will not permit any person to speak to or communicate with any juror. Consistent with that requirement, jurors must not take any electronic communication device, including but not limited to cellular telephones, into the jury deliberation room, or you must turn them off completely. These devices must not be used in any manner in the jury room. Emergency messages can be communicated to the court and will be immediately delivered to the affected jurors. As to the alternate jurors, you are still bound by the admonition that you are not to converse among yourselves or with anyone else on any subject connected with this trial, or to form or express any opinion on it until the case is submitted to you, which means until such time as you are substituted in for one of the 12 jurors now deliberating on this case. This also means that you are not to decide how you would vote if you were deliberating with the other jurors. You shall now retire and select one of your number to act as foreperson. He or she will preside over your deliberations. In order to reach verdicts, all 12 jurors must agree to the decision and any finding that you have been instructed to include in your verdict. Do not let bias, prejudice, or public opinion influence your decision. Bias includes bias against the alleged victim or victims, witnesses, or defendant based upon his or her disability, gender, nationality, race or ethnicity, religion, gender identity, or sexual orientation. As soon as you agreed upon a verdict, so that each may state truthfully that the verdicts express his or her vote, have them dated and signed by your foreperson, and then return with them to this courtroom. Return any unsigned verdict forms. Please swear the bailiff.
Do you solemnly swear that you will take charge of the jury and keep them together, that you will not communicate with them yourself nor allow anyone else to communicate with them upon matters connected with the case, except on order of the court? And when they have agreed upon a verdict, you will return them to the court. And furthermore, do you solemnly swear that you will take charge of the alternate jurors and keep them apart from the jury while they are deliberating on the case until otherwise instructed by the court, so help you God?
I do. Jurors 1 through 12, take your notebooks and your belongings. Go into the jury room, elect a foreperson, and the bailiff will be with you momentarily. As to the alternates, please leave your notebooks on your chairs, go outside, have a seat, and the bailiff will be with you momentarily. May be stipulated among counsel that the jury and all to be admonished and excused at the end of each day of deliberations without the presence of the defendant or counsel by the people and the defense.
Yes.
My first duty is to the jury. With that in mind, I do not intend to keep them waiting. So I would ask counsel or a representative of counsel to remain at all times to be available. With that same vein, I understand that family and interested parties want to be present. And that's fine too, but I'm not going to wait for them. My first duty, again, is to the jury. They can remain in the hallway, in the courtroom, or at the district attorney's office as you see fit. Thank you all.
Okay. How much time? Half hour, 20 minutes? What's your estimate? So
Immediately.
Immediately. Okay.
You understand that we have people from out of town and
To have them, you're going to have them either in the courthouse. Again, my first duty is to the jury. And I will not keep them waiting to have interested parties come. Thank you all.
what about the stipulation about having reread done out of the...
That's up to you. I could be glad to take the stipulation now. Take it as it comes.
We're happy to give it now, and then we could always, I assume, change it based on
The
the
stipulation
question.
meaning that as far as your client or counsel? Or your client and counsel? You tell me. The client does not have a constitutional right to be present.
No, we would stipulate that neither counsel nor client need be present when readback is being read by the court reporter, and can be done so in the jury deliberation room as long as we can change that based on each question.
All right. Is that agreeable to the people?
Yes.
Agreeable to you, ma'am?
Yes.
Very good. Thank you.
Thank you.
I need one from each.
All right, everybody. So I thought, you know what? It's jury deliberation time for a case we've been following now for 42 days. What a marathon of a case it is. And I wanted to come in and kind of give you guys a little perspective because I do pay attention to chat and I see a lot of the confusion. And I saw it during the defense's closing. And I wanted to get into an interesting nuance because I don't know if the jury's picking up on it. This is what Levine was trying to argue. And we have one of these cases that I really like because it's a it causes a lot of confusion for people when they're watching trials. Um, and it's the idea that, in my opinion, Monica is guilty. That's my opinion, right? But, but there's a difference between actual guilt and guilt in a courtroom, and this is what Levine's been selling Monica. This is what Levine was trying to sell the jury, and she very well may meet the guidelines, and I'm going to explain to you why. And I know there might be a lot of outrage, and maybe people will mishear this and say, "How can you support her?" I'm not supporting her. I'm explaining to you what Levine was trying to explain to the jury, and he really didn't do a good job. So, to make this a little easier to see, let me show you an exhibit here, and I'm going to make myself a little smaller here. So, this is the most important aspect to understand right now. This is what this jury is going to grapple with. And it's the idea, it's the instruction, and it's I'm not gonna say it's novel, but this is a California-based jury instruction, and this is what Levine was focusing on. And then we're gonna go through the points. I extracted the points that he was trying to make, but this is what he's going to say here. This is the core of his argument, the crux of his argument. The entire case against Monica Sementilli is circumstantial. There's not a lot of direct evidence. There's really no direct evidence linking her to this. The closest thing to direct evidence would be Robert Baker himself, although he's saying she's not involved. And it's the very presence of Robert Baker in the courtroom offering testimony saying she's not involved is what the basis of her defense is. Many people have said she has no defense. How could she put up a defense? Well, she absolutely does. And it's this instruction that's why she has a defense. So let me read the instruction to you and I'll break it down and let you understand. And maybe as you read it, it may occur to you why this is such an important instruction. It says, before you may rely on circumstantial evidence to conclude that a fact necessary to find a defendant guilty has been proved, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. And it is that line right there, and read it again, digest it, break it down, because that is what it. Now, there's a second part that's even more important. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence and another to guilt, you must accept the one that points to innocence. Excuse me, guys. I apologize. I'm being interrupted. I don't know by who. Give me one moment. All right, I apologize for the interruption. We're actually having an internet upgrade here being done, and they have to run a line to the house. So they showed up unexpectedly. I didn't know they were coming, but they were supposed to actually be here Monday. But anyways, so Balin, that's my dog. I apologize. Balin, and he may make this very difficult. But anyways, so if you can draw two or more reasonable conclusions, and I think I'm going to reread this part from the circumstantial evidence, and one of those reasonable conclusions points to innocence and another to guilt, you must accept the one that points to innocence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. So this is the crux of the defense. This is the entirety of the defense. In one moment. Hey. It's okay. It's okay. It's okay. It's okay. It's okay. It's okay. Come here. Come here. Hey, come here. Come here. Sit with me. It's okay. It's okay. You just come over here with me. All right. All right, everybody. This is Balin. Bye. So, anyways, whenever he gets very worked up when people are at the house at Balin. It's okay. Come here. Hey, right here. So, anyways, this is the crux. You guys have had a chance to read it. So this is the crux of the defense here, because the idea here is this. The idea is that Robert Baker testified that the reason for all of the calls, the reason for the communications, the reasons for all the behavior, post-murder behavior. I shouldn't have said that word. I'll probably get this thing flagged. But the reason for all that behavior was due to an affair, not her wanting to kill her husband. Now, the state, of course, has said no. Robert Baker, as part of a conspiracy, is saying that. But the law states, and the defense's argument is that, again, the jury is required, and again, I don't have that instruction up, but there's also the instruction we all know, which is standard across the board, which is that the jury is required to presume Monica innocent. Meaning, you start from a position of innocence. So you don't have to eliminate all doubt. You just have to argue to the jury, which is what Baker did. And that was that Baker, there you are, see yourself, baby. That was that there's a chance. So what Baker was arguing, although he claimed he believes she's innocent, I don't think he does. But what he was claiming and what he was saying is that, hey, if you believe there's a chance that this was about an affair, and he raises all these issues, and we're going to go over some of the reasonable doubts, and all of that raises a doubt. If there's a doubt in the mind of a juror about whether or not this was an affair or this was a plot to kill her husband, and the fact that Robert Baker came into the courtroom, swore under oath, and said, hey, she wasn't involved, I believe that you very well could find a juror or two that sits on that panel and says, there's no way in the world I'm going to convict somebody when somebody comes into court and says she wasn't involved. When one of the very people that she was supposed to be conspiring with swears under oath and says, no, I was not, this was not a conspiracy to kill her husband. I did this on my own. And of course, the defense gave the jury some particular reasons and evidence to suggest that Baker was a very influential person, that he not only controlled Monica, but that he controlled Christopher Alston, and that he was able to even get Christopher Alston to do this crime for no money at all. So when you put this back there in front of a jury and you apply the circumstantial evidence rule and you look and you say, all the evidence is circumstantial. If there is any other reasonable explanation, any reasonable explanation that a juror could conclude is definitely an affair. So the question is, can you say beyond any doubt at all? Now, what I would have loved to have seen was Levine, again, 70, 80 years old. I don't know how old the guy is, but he's very old. And he seemed to have a problem articulating this. Because what this is an interesting case where a jury literally can be sitting in that jury room thinking to themselves, I think she's guilty. But am I going to apply the law or am I going to ignore the law? And that's the argument that really Levine needed to be making, is saying, listen, you may think this is one of those cases where, you literally are saying you're at the top of the step, but you're not ready to walk through the door. There's a potential chance that this affair could be the explanation for everything. And if that is the case, and you take away all of that evidence, and then you put Alston, who they raised doubt about, and said, hey, Alston doesn't have any direct evidence because he did not directly ever deal with Monica or hear from Monica. He heard from Baker. And Baker's now saying she wasn't involved. You're going to get if this becomes an extended jury deliberation, this instruction is why. And some of the reasons that I'm going to go over with you that Baker, or not Baker, Levine pointed out, could be some of the things that some of these jurors could be talking about. Now, again, the jury is the finder of fact. So they can certainly go, it's not even reasonable to think the affair was the reason for this. The only reasonable conclusion is, again, and this is what the state went through great lengths to argue, although I really feel like they could have really simplified this for them and made this an uncomplicated thing by saying, listen, if Monica herself tells you, and this is why for me, the strongest evidence that if I was back there that I would make an argue to the jury is in the way she dealt with the Viber messages. And Levine can say whatever he wants about it. He can say that, listen, she was trying to protect herself, but here's the problem. And here's where the issue falls. When she made those statements in a jail cell, once those handcuffs went on her and she's being driven down to lockup, she's no longer worried about the exposure of an affair because the affair's coming out. They've charged her. The whole world's going to know. So when she's telling Levine, oh my God, they can't find the Viber messages, it ain't got jack to do with an affair or not wanting the affair to come out. It has everything to do with what she's concerned is in those messages, which I think we all know is what's in those messages, and that's that she was involved in this. Now, the question is, why would she be involved in this? And it really doesn't make sense. And you're right, you can make the financial argument, and it probably didn't make a long-term bit of sense. But in her mind, for whatever reason, she believed Robert Baker was going to take the $1 million or million or so dollars that she was going to inherit, and I guess he was going to somehow turn this into a nest egg that they could live on for the rest of their life. And obviously, Baker was all too happy to try to do this. I think I don't believe Monica was the true mastermind of this because I believe that she was manipulated by Baker into this because he's an expert at that. It's what he did. It's why he had 5 wives. Does that alleviate any of her responsibility? Absolutely not. Not in the least. But what I believe is that he convinced her, he got in her mind, and he got her to do this and participate in it. And guess what? That makes her guilty. Now, the question will be is if there is any struggle back in that jury room because of this rule, because people think to themselves and they read this and they say, well, wait a minute, I think it's logical it could be this. I have a problem convicting her. And I fall back on the Tim Harrington case. The Tim Harrington case occurred, in December, right before Christmas. And the Tim Harrington case was a case that I thought, I really believe we were going to have a guilty verdict. And I did not believe the jury would struggle much with that because there were not Viber messages, Snapchat messages that literally took the victim up to his front door. And then there's, video of him driving from his apartment, and the victim never leaves. And then, not just driving from his apartment, but driving in the victim's car. There's a jogger that picks him up. I mean, you talk about like delivering guilt beyond a reasonable doubt on a platter. And the only reason why I even thought the jury might struggle was because of who his attorney was, Kevin Horn, who was a big time guy in Mississippi. And I thought, well, maybe that would be the reason why a hung jury would come in, because of his influence, or somebody in there really likes him and or maybe has a problem with the fact that it dealt with the controversial issues it did in that case for that area. But no, come to find out, the only issue that juror had was, hey, I'm not comfortable convicting somebody without a body. Now, you might say, well, this case has a body. It does. But you might run into the same type of thought process. We had the real killer come into court, swear under oath that she wasn't there. And there might be a person back in that jury room, or two, or three, or 12. It's California, for God's sake. You never know what's going to happen. That might say, you know what? We can't convict her under these circumstances. And that is exactly what Levine wants. That is exactly the selling point. That is exactly how he probably extracted $1 million from her daughters in her defense to pay for her defense. It's exactly what he walks into that courtroom. And I guarantee you, he's sitting there in his law office today thinking to himself, there's no way they can do it. The moment we brought Baker in and Baker testified, that's evidence on the record. That's testimony as evidence. And the moment we put that on the record, it raises doubt, because it becomes a reasonable explanation. And there's no way that you can sit here and now say that it's possible it wasn't. You might say you don't think it wasn't, but there's no way you can say for sure. And as you can see with this rule and this instruction, if there is a reasonable alternative, and if the jury finds that, they have to find her not guilty. It's the way the law works. Now, let me switch up here really quick. And we're going to pull up a document here. I want to go over a document here that I prepared. Let's make sure there it is. Is it coming up? Hopefully it does. There we go. Okay. Hold on, baby. Hold on. There we going soon. All right. All right. So these are Levine's reasonable doubts. So let me take Bebe and I down and shrink us. Unfortunately, as long as we have people out here, he's going to be wanting to. So here we go. So these are the points Levine made in his closing. So these are the points they're going to consider as reasonable doubts. They proved adultery, not the big M. And this is a quote from him. They proved that Monica had an affair. They did not prove the big M. The defense leans heavily on the idea that character assassination is not proof of homicide. Monica's infidelity, while damaging, does not equate to intent or participation. The jury is warned not to conflate moral failure with criminal guilt. Again, he argued that the affair was known early, so why no immediate arrest? So this is something that, he says that, all right, if the law enforcement believes she was so guilty, why didn't they arrest her right away? And he's saying essentially that they didn't have the evidence to do it. And then when they arrested her, they still didn't have the evidence to do it because they had to do a Perkins on her. Why didn't they arrest Robert Baker? His DNA is all over the scene. The implication is that they weren't sure, that there's lack of urgency, that they weren't sure about her. And the whole point of this is, if you're kind of understanding the theme, and you may look at this and go, well, why is that? Why would that be a reasonable doubt? Well, it's a reasonable doubt because what he's arguing, when you apply it to the instruction, of, is there another reasonable alternative? He's saying even in the police's mind, there was a reasonable alternative. They thought it could just be an affair. They didn't think it could be that. And then they didn't arrest Baker because they didn't think they had enough evidence. And what he's saying is that situation has never changed. The Perkins operation got nothing more. Christopher Austin wasn't able to bring anything more. And now Robert Baker, the individual they expected to cut a deal and come testify against her, came into court and said the opposite. So maybe 20 years ago, Levine would have made a thunderous argument that would have been a little more clear, and it would have been saying, listen, their whole case got turned against them. And he did make that argument, but it was not as clear as maybe could have been done. They built the case around an affair, not evidence. And then perhaps the most important piece right here that I think is what is just as important as the Viber message statement that were in the whispers, is the timing window was too small. Now, this is something that resonated with me because, but I also think I found that I could dismiss it as well. But I'll explain. But what does he mean by the narrow window? The narrow window meaning that she was in control of the timetable. In other words, she creates the scenario to where the daughter's coming home because of what she's telling the daughter to do. And what he's saying is that if she was aware that this was going on, she should have been and would have been intervening to say, daughter, come here, daughter, come to Starbucks. I'll meet you at the eyeglass place. Now, what I would say, though, is I think that if you're operating like that, you may not want to do those things because you know something is going on at your house. And then they might come back and say, well, wait a minute, mom acted strange that day. She invited me to Starbucks. She told me I couldn't go to she calls me up and says, no, I'll come. Which, again, if she was stuck. So what I would say to that is the window, although, yes, I see what they're saying and what they're trying to do with it. I feel like the window is, she was stuck with that window. She couldn't get in the way of that window because when you have a guilty conscience of what's happening and you're worried about how you're going to look and you're planning things down to the fine tuning way they were, which is stealing the DVR, trying to stage this as a robbery, she knows she has to go with the flow and she knows she has to take the risk. And she's figuring Baker's going to have to get out of there and they're going to have to make it work. Because if she herself, gets in the way of this, and for her, it's like, well, if she comes home and finds them there, I guess they get caught, and she walks in and she's figuring, I won't look like I'm guilty, But if I get in the way of my daughter showing up and I start doing suspicious things while this thing is going on, that could very well come back to haunt me. So I look at it as, those are just in the moment decisions she made. I don't think it's I don't think it's the strongest evidence because then when you say, well, why did she decide to say to Robert Baker in the holding cell, they can't find the Viber messages? That to me is it. That's the whole case right there. Because she should have wanted those Viber messages found at that particular moment. What she should have been saying is why did we delete them? We were trying to cover up an affair, and now we may have deleted the only evidence that exonerates us, Robert. And that's not what she did. Not to mention the other major piece, when you couple it in, is the fact it's the tracksuit evidence, right? She saw what he was dressed in. And we know the defense did not say she did meet with Robert at Target. They just said it was a normal meeting place. They didn't deny that. And they met up. And they proved that they met up. And they showed that they met up. So when she sees that tape of the two people running away, and she sees a man dressed exactly like her lover, there's no doubt in her mind who she's watching. And then she goes and continues to build a life with this guy. She goes on vacations with this guy. She exposes him to her daughter. And then we have the Viber messages. That's it. Case is over. Now, I hope the jury goes back there and they live in that, because there is no reasonable explanation for either of those two things, in my opinion. But again, this is what the defense was relying on. The state's evidence is entirely circumstantial. We just talked about that. If circumstantial evidence supports two reasonable interpretations, you must choose the one that points to innocence. So, and that is true. It is all circumstantial, but I do believe those two pieces of evidence, there is no reasonable explanation. And then they say the surveillance proved nothing. So the motive, the money doesn't hold up. The prosecution inflated the life insurance money. Honestly, like I said, for me, the motive was a hesitating factor when I first was listening to this case, and I was wondering what they were going to do with it. And I know they went to great pains, and I know that I believe it's Heather Stagel yesterday went to great pains to explain away this because I think it got personal between her and Mr. Malatesta and Levine, and she wanted to embarrass all those guys. But the bottom line of it is this: Monica was not of sound mind when she was making these decisions. Monica was not considering things the way she should be considering things because she was under the influence of Robert Baker. And Robert Baker convinced her, in my opinion, that he was going to handle it all. And she went with it because she was under his control. So I thought that was, to me, a less powerful argument when they tried to say Monica was the one that was in control. To me, that doesn't sway. That turns the whole defense on its angle, on its head, and says, no. When you have a woman who's under the control of someone like Robert Baker, I mean, again, remember, this is the same man that got a young lady to, his stepdaughter to not just marry him, but also follow him into the industry and, conduct herself, I'm sure, however she did. Remember, Monica was out sleeping with other men and putting ads in Craigslist while she has a husband in the town she's doing it. There is powerful evidence that says Robert Baker was influencing her. That does not excuse her participating in a scheme to kill her husband. It's the same as Laurie Vallow, right? She was under the power of Chad Daybell, and she went and kills her kids and her husband. Her kids are lucky that they didn't end up killed in all this, although I think Robert Baker saw other means for them. He had other ideas. So, yeah, this is particularly sick. This is particularly crazy, and this is particularly disturbing. And this takes me to the final one. Her daughter still believing her. Of course, her daughter still believing her because they've been convinced by, I guarantee you, by Levine, who says they don't have the evidence. And her daughters want to see the best in her. It's hard for them to see that their mother would do such a thing, such a terrible thing. But I believe that the jury, in the end, here, all right, baby, I'm gonna let you down. You can go check it out. Balin, nobody's there. They left. But I believe that they're going to, eventually see the truth. And it's a hard truth. It's definitely a hard truth. It's a hard thing for them to grasp, for them to consider, for them to look at, for them to know that their mom would do this. But if this is an extended jury deliberation, that will be why. If she somehow gets 12 jurors who reject this case against her, it will be that instruction that will be the cause. And I don't believe, though, that when they get back there and they deliberate this for a while, and I think it's going to take a day or two. It's been a long, long trial. So a day or two or three would still even be a short deliberation in this. Because remember, the rule of thumb is 1 hour for every 8 hour a day. In this case, we've got about 42 hours of deliberation before we would even be thinking that this is an extended deliberation. And remember, in the Scott Peterson case, that jury deliberated for days, and they convicted him. And the public was very much in the belief that he did this, and there wasn't much question, in the public's eye. But the jury sat back there and deliberated because they had a circumstantial case against him, and they have a circumstantial case against Monica. So therefore, this is going to take a little bit. But I believe at the end of the day, those two pieces of evidence, the Viber evidence, the fact that he wore the same clothes that he wore to Target into to do the crime, and they would have seen this, and they would see him running away in the same clothes. I think that's going to be the point. That's going to be the tipping point back there. So But I want to say thank you to everybody for sticking with us. Thank you for all the wrenches and the new wrenches we've got. I'm going to kind of go through here. Kate, Andy, Reagan, Georgia. Um, I'm trying to look through to make sure I can see, who all's in there. Some of the ones I see right now, just off the top of my head that I can see. But I appreciate everybody that's in there. I appreciate all the supporters that have come in and watched this. We've had a good trial, and I think it's been a fun one to watch. I know there's a lot of people that are probably tired of it, but I think it's been interesting. I think it's been one that it's like watching a real Dateline NBC documentary unfold on our screens with all of the stuff, and it's one that's to me I think it was funny because I felt like when Deb came on, Deb Obad, um, I think that she, to me, really hammered home just like the real worldness of this. We're watching this thing unfold, and it seems like it's this thing, but it's like you start to really get this idea that it's like here's this tight knit group of friends, and I could almost just start to see it now. The rumor mill and the rumors and the innuendo and everybody talking and Deborah Bad out there calling the police and saying get a tracker on them, and everybody's like like they can't believe it, but they're like, holy cow, she did this. And then she gets arrested. And then it's still somewhat of a divided circle because it's like, there's no way. Like, really? And then, like, Robert Baker did this, the racquetball coach, who, of course, was the basis of a lot of rumors. And then it's like, holy cow, did they really do it? And it turns out he did. He confesses to it. And then it's like, well, was she actually involved? And again, everyone that's close to the situation is like, yeah, she was smitten. She was taken by this guy. And, to me, um, the young guy, Matt, I mean, who she at first approached, to me at the very beginning of this, I was thinking to myself, some strong reasonable doubt in there was about the fact that she told him she didn't want to give up a 20-year marriage. But then the defense inadvertently started to reverse course on that as they started to demonstrate to me, especially when they called back his buddy to the stand, who he plays basketball with. It's escaping my the name of him is escaping it, but he was a guy that um, uh, um, talked about Robert and all of what he did with the ladies that he was being an agent for. And he kind of got into that. And at first I thought, okay, well, this is interesting. The defense is going to go and say she was trapped. They didn't do that. Well, what they did do is they did explain that, they didn't touch that because I think they were worried that that could turn around on them. I mean, they brought it up to say Robert Baker was a manipulator, but they didn't go right there. And that tells me something. And then I started to realize, well, they didn't go there because if they went fully there, it would displace one of their arguments they want to make, which is why would she leave her husband? Why would she do these things that don't make any sense? And there's an answer for it. She was being manipulated. She was being Robert Baker got her under his control, and she didn't care about any of those things. She didn't care about logic. She didn't care about anything. And you have to not care about logic when you engage in this. And most of all, I believe Robert Baker led her to believe that he had all these connections, and this Birdsall guy I looked him up. The gentleman I saw online, you can look him up too. He's like a Department of Homeland Security, like in some sort of like does electronics or tech, like spying tech. So I think, Baker's like, I got a guy who can help me. And I think Baker starts floating this thing. And I think Baker at one point may have even been angling to try to do this. I think he got caught off. I think Birdsall kind of was telling him, work her, get her on board. She's got to be fully on board. We can't do this because I think, again, their plan was to get the money and then have Monica under their control and extract all the money out of her like they would do with any other woman, whether it's managing them to go do nefarious purposes on various adult circuits and things that they might be agenting women for, or you go get a woman to help you kill her husband so that she can get a hold of his fortune, and then boom. So, to me, I think he had her under his control. Um, and I think that she regrets it now. I think it's one of those things like the Adelsons, who, especially Charlie himself, who probably regrets ever getting involved with Magnano and the gentleman there that ended up doing this. And it seemed like, at the time, I guess it seemed cool. It probably didn't even seem completely real. And then it happens, and then reality sets in. And then you find out that these alleged people that are criminals and, um, you know, criminals and so-called underworld characters are really not anything special. That's why I always thought it was funny when they say criminals go to jail to get smarter and learn how to do crime. Oh, really? Your prison is not where the smart criminals go. That is like failed criminal university. You got caught. So that's great. They can tell you about how they got caught. They might tell you about some crimes they did that they didn't get caught for. But the reality is every single one of those guys got caught. So you want to go learn from them? Fine. You want to go learn to be a dumb criminal? Fine. That's why most of them all end up back there again with, having reunions over and over again, because the dumb get dumber and dumber because they're using each other and learning from each other. And all they do is go out and get caught. I mean, they might turn to crime. They might network together, but it's a network of the dumbest criminals ever. And that's exactly what Monica had on her hands. Now she was obviously impressed by this and trusted him and whatever. But it's really a sad story. But I think that, and then like if to me, and this is where I think the defense should have embraced the mind control aspect and said, "Oh, she was under mind control. She was under his control, and as a result, that's why she missed all these things." I mean, they could have done that, but they were afraid because that tells you that they knew that the truth of the matter of this is she participated, and they wanted to be able to argue that, hey, it makes no sense that she would do X and she would do Y and she would do Z. And instead, they wanted to leave those arguments to be available as opposed to saying, hey, look, she was under his control and this is why she missed those things. And perhaps I think that would have been a better argument if the defense would have dove into that, of saying she was being trafficked. She was being set up. This guy is as evil as they can be. I mean, listen, you flip the argument of the toothpaste on its head. Who the hell does what she did with the toothpaste bottle? I mean, who does that? You don't do that sick crap. Who's sitting in a lockup doing all this weird crap in a lockup, right? That's demonstration. And they should have had an expert come in and say, this is signs that this woman, and Robert Baker's done it. I mean, listen, that is, and if I'm the defense attorney, I'm not putting him up there lobbing friendlies at that guy. I'm putting him on the stand and I'm going nose to nose with him, and I'm pointing out you traffic women. And I would have been going through his stuff. I wouldn't have made him a friend. I would have said, hey, and maybe he turns and says, okay, well, now I'm going to say your client did it. That's great. Yeah, because you're going to say my client did it. Why? Because you want to punish her again? Why? Is this your way of controlling her? Like you had all the photos and you had all of this? That's what you did. You I don't know if I'm allowed to say it on YouTube, but turned her out. I mean, that's what he did. And that's what those guys were that were on the stand. You never come across them in life. You may not recognize that. That's what they were. And that's what they operated in. That's the world they operated in. And what he saw in her was an opportunity. Now, she should not have participated in this stuff. She should not have done it. And she should not have had her husband killed. And you know what? She's going to have to pay for it. But that's what it is. She lives with that now. Now, maybe that jury, in my opinion, what you would have been doing is similar to what's going on in the Gulf Turk case. You're going to make an argument that maybe they excuse some of this because they could find her guilty of conspiracy and not the other, and there would be a difference in the sentence, and she might have an opportunity to see light in like 15 or 30, 20 or 30 years, although you see that it's not very likely you get parole in California. But, you know, well, Marina, put the comment up on it. I mean, are you ignoring do you not believe that Robert Baker was a seasoned man who knew how to put women under his control? I mean, I think that makes more sense. I mean, if you want Monica to be this bad person who controlled Robert Baker, look at the history of Robert Baker. You can't ignore that. Look at the friend they put up. Look at the background of what's going on. Look into Birdsong. Go look into Birdsong. Look into who he is. And Birdsong if you look at Austin's testimony, he talks about Austin was brought to Vegas to drive Baker's girls around. Baker had 5 wives. He had a wife and he had multiple women that he was working or living with. He was an agent in the porn industry. Or I hope I can say that on YouTube, in the industry. Okay. So he was absolutely, without a doubt, someone who had the ability and had the experience of influencing women to do things. Uh and yeah. Now, again, that doesn't excuse. So do not confuse things. I'm not excusing her behavior. She did this. I think she did. I think she absolutely had full knowledge of what was going on. I don't think she cared. I think it explained why she did it, even though the finances weren't there. It wasn't about finances. It was about he had made her so obsessed with him that she would do anything. She would kill. Look, go check out the Vallow, or well, that trial's already gone, I think, where she killed her kid. But it's this Laurie Vallow thing. It's the same thing Chad Daybell did to her. Some of these guys know how to do it. They know how to get into a woman's brain. And not just a woman. I mean, women can do it to men, I'm sure, but we're just going to talk about human beings. He's a human being that knew how to convince another human being and get into her brain and absolutely control her. Absolutely control her. But like I said, if the jurors, I hope, well, if Bodie, if hopefully if the jurors were paying attention, there's 2 pieces of evidence that you can apply the circumstantial evidence rule to, and there's no reasonable explanation for them. There's no reasonable explanation for how she could have not recognized Robert Baker and gone straight to the police, other than that she was involved. And there's no other reasonable explanation for why she would have thought to herself, "Oh, they can't find these Viber messages. Oh my God!" And she's sitting in a lockup saying this. That doesn't make any sense. There is not a reasonable explanation for why she wouldn't be saying, "I hope they find the Viber messages. They got to find the Viber messages. That's going to free us. That's going to set us free." So, but I do believe, based on the length of the trial, I think that we're probably going to be sitting here for at least a day or two, if not more, because of the length of the trial and just the fact that they're going to be discussing some things. And I think there's going to be some people back there that might feel a little hesitant to deliver a verdict right away. When you have a witness that comes on the stand who's exonerating the person. Monica got hammered. C. Sola says, yes. I'll put the comment up here. Yes, Baker was a sociopath, but she wanted her husband gone. Yeah. Well, right. But I'm saying, and clearly there's got to be a part of her that's open to that manipulation. So I'm not saying that Monica wasn't, that there wasn't but that there wasn't, a part of Monica that allowed it to happen. There absolutely was. In fact, we know she was having affairs in Canada. So it wasn't a far line, but Baker recognized it, and I believe it was Baker who puts the idea out here. I don't think Monica's going, I'm shopping for someone. In her mind, it was it. But when she got around Baker and he laid it out for her, and he lays out, Birdsong is involved in this, guys. I mean, you got to understand that. That's why he was arrested originally. And then he was released because Austin didn't provide evidence on him, and they were expecting him to give something on Birdsong, and he didn't know anything about Birdsong, and he couldn't link Birdsong to this. And then Baker has refused to say anything about Birdsong, and Monica isn't saying anything about Birdsong because she's convicted. you know, uh, you know, But I think, that is undisputable evidence that, these guys have a history. I mean, I think the problem that you guys are missing here, or the part that you guys are missing here, is the part about the history of these guys. And you've got to look into the background. Again, Birdsong, I'm not going to put it up here because he's a guy who's free. He's right to his privacy. You've got to go dig into Birdsong. That's all I can say. You've got to dig into Birdsong. And when you see the history, you will understand what I'm talking about. Not all of this, well, none of this, nothing was really presented about Birdsong in the trial. But you've got to go and look at Birdsong. You got to go look into his history. You got to go in and you've got to look at what the potential aspect he brings. And he was involved in the industry down in Vegas. He's involved in a world in Vegas that this stuff happens in. And Baker was a guy who told her, I can make this happen. She had to green light it. And that's why the idea here was they brought it up. She was not comfortable moving forward in July. And Baker worked her until she greenlit this. And then when she greenlit this, they put it into effect. And there was a reason for all the tracking and all the tracking devices, and it wasn't because Baker was doing all this behind Monica's back. And yes, he convinced Monica that if they got caught, that they would again, that he would say that he went to the house to deliver her a birthday gift, and Fabio saw he's a jealous guy, attacks him, and he had to kill him. And then that would alleviate Monica out of this. And she was convinced they could make this the way it was, and she would walk away and she would get out of the 20-year marriage and she would leave all of that behind. So, he is the key to this, and he is the one that still needs to be brought in. And I don't want to sit here and go too wild on that because he is not currently in, and I'm not going to go into it. He's not behind bars. He's completely free today. So I'm just going to say, do your own independent research. I'm not going to go bringing it out, and I'm not going to go on a campaign, and I'm not going to go. One day I do believe they will hopefully get him. Well, I think. Listen, remember, there's also another aspect too. Remember, Fab lied about his colonoscopy. Remember, maybe some of y'all missed that. Why did he lie about the colonoscopy? There's stuff going on. There was stuff going on that exactly, Kate. And there are guys out there, but there are people out there. There are individuals, and I'm not even going to say, listen, there are women out there too that can do it. We're not just going to put it to one gender. There are individuals out there who have a way, and because believe you me, it can work on both sides. But she was ready to be influenced, but he took advantage of that. But that's why she did these things, and it didn't make sense with the amount of money she was going to get. It didn't make sense with how this was all going to go. So I've got to step away though, guys. I've got to go. I've got a lot of things going on with my family. Unfortunately, during all of this, trying to cover all these trials, my wife's mother had a massive heart attack over the weekend, and she's not going to make it. We're going to be heading up, and unfortunately, she's in hospice care, and they're making her comfortable until things, play out, but it's not going to be long, unfortunately. So it is extremely very sad. My wife was very, very close with her. They talk like every day. So it was not expected. But it's just one of these things that, life throws at you. But but I wanted to come on because I've seen all these things. I appreciate that. Dina or Dinah, I'm not sure how to pronounce the name there. Hopefully I gave at least one of them was right. But I appreciate everybody. And I'll be here. We're having up, and I'll try to jump in, of course, and comment when we get a verdict. And maybe they'll shock us. Maybe they'll give us a quick verdict. I can absolutely see how they could do it. Like I said, there's two things that stick with me. If I was back on that jury, I think I could have a verdict in about 2 hours. But thank you guys. Thank you, Andy. Thank you, Marina. Thank you, Kate. Thank you, everyone. I will see you guys soon. I will be talking to you soon. We've got lots of other trials to check out while you're waiting on this verdict. Check it out. Ingolf Turk is in closing arguments. Check that one out. That's a really particularly interesting one. I will be giving lots more talk about that because that one's a really interesting one. as well. So we'll see what the jury does with that. My prediction is he'll have a manslaughter conviction, but he's not going to get hit with the top level, but he's going away for something, but because he won't do, if he does get that in New Hampshire, he won't see more than 10 years, and he's already been there 5, and he even likely could get parole in 8. So, but I think they're keeping for 10. So he'll get another few years in, and then he'll be gone and back to Germany, I guess. But anyways, talk to you all soon, guys. Keep the chat going, and look forward to seeing what this jury returns with us. Hopefully they get a verdict. I think they will, and I don't think it's going to go well for Monica. But talk to you guys soon, and thank you very much.
alternates are not present. I received the following communication from the jury. They want the recording of Austin's Perkins conversation, if possible. At that time, I sent back the note for clarification by the jury, and then they said, we'd like the recordings and or the transcript, but the recording is preferred. As I understand it, there is no recording or transcript that is in evidence. Is that correct?
Correct.
Yes.
And that's my answer to the jury. We can have the jury and alternates, please.
Would you buzz in the jury and go get the alternates?
You want to say there was testimony?
I do not add to questions. I answer them. The jury and also now joined us. Good afternoon. Juror number 10, you are the foreperson. Is that correct?
Yes.
I received the following communication from you and the jury that you wish the recording of Austin's Perkins conversation, if possible, at which time I sent the note back for clarification. We'd like the recordings and or the transcript, but the recording is preferred. The recording of the Perkins operation of Austin and any transcript was never received in evidence. That should answer the jury's question. It's now 4 o'clock. I'm going to let you go. The admission applies still now. And you'll return tomorrow. I understand because of rehab, you're coming back at 10 o'clock. Is that correct? Okay. Have a good evening.